right. Okay, you may be seated, and we'll begin with Mercury Insurance Company. Crystal, how do you pronounce the last name?
NEVCHERLIAN, Your Honor.
All right, thank you.
May it please the court. My name is Michael Falkowski. I represent the appellant, the plaintiff in the lower court, and I was the trial counsel, so whatever mistakes were made, you can send them my way. This is basically an automobile accident, Your Honor, that occurred back in 2007. It's a one-car accident. My client was in the vehicle with her husband coming off the freeway at New Smyrna Beach, and he lost control of the car, went onto the side, struck a guardrail, and came to an abrupt stop. The jury found that the driver of the vehicle was in fact liable. The question really revolves around issue of damages and, more importantly, the issue of force of impact. At the time of the accident, my client was rushed to the hospital.
There's substantial competent evidence to support the trial judge's ruling. Obviously, you're going to lose, right?
I know that, and I don't believe it is.
And so I think to get to, as far as I'm concerned, the heart of the issue is that there was testimony that she had suffered injuries in previous accidents, and that the injuries that she was obviously were not caused by this particular accident, and therefore were not compensable. So
let me get to the crux.
All right.
3/4 of the trial was made on the prior accident in 2001 by the defense. First defense tactic, shift responsibility, and that's what they did. The problem is this: the first accident, she did complain of neck pain, but there was no residual effect of the neck pain. There was no permanency for the neck; it was to the shoulder. There was no treatment for the neck from 2001 up to the time of this particular accident. There was no the MRI taken of the neck back in 2001. Prior to that time, there was a normal MRI, normal X-ray.
Here's what I'm getting at, and I don't mean to keep interrupting you, but Dr. Broderick was the
defense doctor.
Yeah, and he was unwavering in his testimony that her injuries couldn't have been caused by this accident.
May I address that?
If that's substantial competent evidence, I mean, what do we do with that, and you know, how do we get around that? I mean, that
to me it's simple, and the course, I apologize, the course would indulge me into taking the totality of the evidence.
Okay.
If you don't mind, Your Honor.
No, go ahead.
The totality of evidence is, how do you defend this? If there's a conflict of fact with substantial competent evidence, I agree, I lose. I'm here because I believe there's substantial competent evidence. The reason being is that the defense hired 3 experts to determine the force of impact, which has a direct bearing on injuries and the testimonies of the 2 physicians. That is, did the force of the impact cause these particular injuries? The evidence was that Dr. Ipser from the University of Florida testified that the force of impact was such that it was minimal impact to the vehicle and therefore the occupants of the vehicle. That evidence was incorporated by both doctors, Dr. Broderick and Dr. Foley, with respect to their decision as to whether or not the injuries were in fact caused by this particular accident in question.
Dr. Foley testified that Crystal's chronic neck pain problem predated the accident too.
Again, Your Honor, there was no evidence to support his contention because there was no complaints or problems with neck pain from 2001 to the day of this accident. It was an opinion of his, not predicated on facts. Again, we're going to deal with the totality of facts. The facts in this case are straightforward.
So your argument is basically that these experts that rendered that testimony basically were wrong because they were not basing their opinions on the facts and circumstances and the medical testimony, the medical documents and the medical history that they observed. I mean, that was just all wrong on their part.
Your Honor, exactly. If there's an example of this in the flow chart of the pain diagram in 2001 of Dr. Rhodes. The pain chart asked, where are you hurting at that time, the last visit? And the pain chart indicated just her shoulder was having difficulties. Dr. Broderick took that pain chart, and it's obvious, and it exhibits that there was no pain or indication in the neck. Yet he says, oh, that particular pain chart shows pain in the neck. Again, contrary to that particular pain chart and contrary to the record. But more importantly, Dr. Broderick and Dr. Foley stated the reason they made the comments they did is predicated by Dr. Foley's testimony that the particular accident did not produce a particular degree of energy to cause these particular injuries. And again, I need for the court to look at the simple fact, the photographs that he based his decision on. Actually went to the accident scene. At the time he went to the accident scene, the girl was replaced. He couldn't tell exactly what happened. The field had gone over. There was nothing there for him to determine the course and scope of the vehicle. He didn't know the speed of the vehicle. He didn't know the direction of the vehicle. He didn't know anything about the accident first except for the photograph. And the photograph did not show the door on the right side where...
all this was argued to the trier of fact, to the jury, right? I mean, they heard all of this and you made all of this argument to them. Apparently they just didn't accept your argument, right?
But Your Honor, it's not a question whether I accept my argument. The question boils down to is they're going based on opinion. How can that opinion stand with respect to what his opinion was, because it was not based on any facts. The fact of the matter is, his opinion was based on a vehicle photograph that was not accurate as to what it was after the accident.
Some of the doctor's testimony was based on physical issues, right? I mean, Dr. Foley talked about a certain kind of tear and said that's not a tear that would be caused by a single incident, right?
Yeah, and if you look at objectively Dr. Foley's testimony, he said, based on the X-ray we're finding, if there's no swelling, et cetera, there can be no injury. That's the sort of his, that's what we met. We still have the issue of the knee. But if you look at the MRI, et cetera, done after the first accident, it had no swelling, et cetera, under Dr. Foley's criteria, and under that concept, there should be no injury in the first accident. So he's creating opinions, not necessarily based on facts, but his own suppositions, his own speculation. This is the same guy who was told by the court, you can't talk to a juror, and talks to a juror, and maybe that's not bad.
So you objected to that opinion and tried to keep it from coming in?
I moved for a mistrial, and my mother was denied.
Did you object when the question was asked for that opinion?
The opinion of the...
His opinion that it wasn't related to this accident, did you object? Say there's no proper foundation to give that opinion?
No, I didn't object.
How about the other two doctors? Did you object to their testimony as well, based on the fact that it wasn't based on any medical records?
Not except in the motion for new trial.
I mean, I didn't understand what you just said.
Only in the motion for new trial, because I moved to the evidence. What I did, here's the situation. Do you object, or do you let the evidence speak for itself? What I want this court to do...
If you don't object and let the evidence speak for itself, and the jury accepts it, then what are we supposed to do with that? I mean, how do we find an error there?
And that's what I'm trying to relate to the court. If the underlying foundation of the verdict fails because the opinions of the doctors were predicated upon information was false or information was not proper, then the entire verdict must fail. That's why I'm saying there's no adequate evidence. In this particular situation, both Foley and Broderick relied on Ipser. Ipser's testimony...
Why isn't your proper method to preserve that error to object before they give the opinion and say improper foundation, as opposed to let them give the opinion, roll the dice, see what the jury does? If you don't like the jury verdict, then go back and say, well, the opinion shouldn't have come in.
Well, Your Honor, if you read I'm sure you read the record. I've appealed. I made motions to strike, motions to dismiss, motions on a number of occasions regarding Dr. Ipser's testimony, and it was all denied. So at some point you feel like you're exercising futility. And again, that may be my fault. I understand that. But the point is, as I understand, if we're trying to seek justice in the case, if you're trying to look at a case as to whether or not there's evidence to support it, if that evidence is tainted, if that opinion is based on evidence that's false, it must fail. And that's what I'm saying when I look at the totality. Could Broderick's testimony and Foley's testimony alone solve this situation? Maybe. But the point is the defense made their decision to say, hey, we're going to tie all these things together, and since they did tie these all together, I realize I'm trying to overcome something this the panel's trying not to do. Let's overcome a sanctified jury verdict. But I don't believe this particular verdict is based on the situation of the evidence, but it's based on some animus towards my client, given the prior arguments of 3/4 of trial on a prior medical condition, which in fact was not really relevant, which they made relevant. the fact of the matter that they had experts testify.
Yeah, all this is supposed to be fleshed out in discovery. I mean, if you take the doctor's depositions and you find out that the basis for their opinion is faulty or false, then that gives you an opportunity to bring it to the trial judge's attention and say, Judge, they're not competent to testify, and have all that done before trial. But in essence, it seems to me what happened is they testified before the jury, and the jury made up their minds. We're going to believe these doctors, and what they're telling us, we believe is truth. And
that's not true. I object. I moved during the first trial, had Ipser not testify. The court ruled he can't testify. So once the court ruled he could testify, and he allowed him to testify, then I think it is a basis for me to make this argument now that the court had that particular.
Did you similarly object to the Dr. Foley and Dr. Broderick?
Dr. Foley, Dr. Broderick, yeah. I did to Dr. Ipser, Dr. Foley, and Dr. Broderick. I did not do so because, again, it was my contention, and I don't think there's anything wrong with that contention, that if they accept this information, it is tied to their testimony. If this fails, they're going to fail. Again, in the heat of battle, when you go through 4 or 5 different motions, if you read the transcript of all the different arguments you made, the bottom line is you make decisions on a rapid basis, and my contention and my position was, and maybe I'm wrong, but if you're a trial lawyer, you look at it. Here's an opinion. You're stuck with the opinion. How do you fight the opinion? You can't fight it at that particular level because the evidence is going in. The only way you can fight it is on the appellate level because now you show that the evidence upon which this verdict is based is flawed. And that's the key. That's why I say you have to look at the totality of the situation, not just could this doctor say this or could this doctor. They made the decision to tie all these doctors together and these experts together. And if one of those opinions are flawed and not correct and inaccurate, then all the other testimony fails, and that's what the appellate court's for, to say this is what's wrong. And I guess Judge Salah, you don't agree with me. You said you have made the objection and brought it to the trial court's attention based on Dr. Ipsler, and then kind of assumed that would kind of flow over into the. Not assumed. An assumption means I think, I know. As I understand, Your Honor, opinions of experts must be predicated upon the evidence. So when Ipser was objected to and his evidence was allowed to go in, that is to say, testifying on photographs that were in fact inaccurate, totally inaccurate, to make his opinion testimony false. Then when these 2 other doctors, Foley and Broderick, took that, took these particular things and adopted to them and said, yeah, our opinion on these injuries is based upon Foley's situation, then the whole thing is flawed. That's the nature of the beast. Okay. That's what evidence is all about.
Counsel, before you're out of time, would you spend a few minutes talking about why you assert in your brief that your client was blamed for the removal of the 2 jurors following the conversation?
Okay, let me talk about that. We have a situation where on the mistrial, with respect to that, it was the 2 jurors were taken out, and it was a situation where, I'm not saying my client was blamed, but it took away from me the ability to attack this doctor's credibility, in the sense that here a physician who is an expert testifying, he's testified on numerous occasions, was admonished by the court before he went out to not to speak to the jurors under any circumstances, did so anyhow, regardless of whether the gist of it.
Problems with the cure that the judge came up with, not with anything else, correct?
Say again.
The problem is with the cure that the judge came up with. You're unhappy with.
Yes, I feel that because I couldn't attack his credibility at that time because of what happened, him talking to the jurors and not reporting to the court. It goes to the credibility situation. I was precluded from that, and as a result, just removing those 2 jurors was not sufficient. I'm not arguing about 5 jurors. I'm moving for mistrial by the fact that here I'm dealing with an expert. That what can I do? The situation nowadays is when you're dealing with experts, there's not much you can do. They give their opinions, and where we gone, what is based on, we don't know. In this particular situation, their opinions was in fact based upon flawed evidence, flawed testimony. And as a result of that, the verdict was flawed. In other words, there wasn't a viable situation as to why there was a verdict in this matter against my client. There was all the conflicts of evidence that in this case was created by facts which were not in fact facts but based on opinions that were predicated upon wrong situation. For example, in me, their doctor, Broderick, said she had prior knee problems, degenerative case. Dr. Foley, their other doctor, says, no, she didn't. The conflict was created within their own testimony, the totality of their testimony. Their Dr. Foley indicated that the trauma, the result of the surgery was due to a trauma that occurred after the accident. There was no evidence of that. Again, opinion based upon pure speculation.
The evidence was a review of her physical condition, right? Wasn't it his testimony that there must have been, this would have to have been caused by a trauma?
No, he did not review. All he did was review x-rays. Foley was a radiologist. He was not a clinician, nor did he ever see the client. No, that's not true. He was a clinician. He just reviewed the x-rays. And that was it. And that's how he made his opinion. So, and all he did was review the x-rays and MRI. He didn't review the medical reports.
That beat means you have 5 minutes left. Now I'm down to 4:38 if you want to reserve.
I'll save it on
rebuttal.
rebuttal for what it's worth.
Okay, very good. Thank you.
May it please the Court, James Wachewski for MERCUR Insurance Company. The bottom line in this case, first of all, is the fact that the appellant in this case, who was the plaintiff below, did not properly preserve any issues as to the introduction of evidence of the three experts that the defense used at trial. He did, at the trial level, move to strike Dr. Ipser, and obviously had an opportunity to do that. The trial judge gave the matter serious consideration. There is actually, on my answer brief, I actually listed the specific pages on the record where the trial judge discussed what he thought about the issues that were raised by the plaintiff, and he actually eventually did decide to allow some limited testimony from Dr. Ipser. The problem after that is this. The plaintiff's argument basically is that all of this evidence should be disregarded. Basically, he's asking this court to reweigh the evidence. But he hasn't raised in this appeal any issue about an impropriety on the admission of the testimony of Dr. Ipser or Dr. Foley or Dr. Broderick. All the evidence came in at trial. All of the evidence was presented to the jury. The plaintiff's counsel was given an opportunity to make all arguments that he's making here today to the jury, to explain why they should disregard the testimony of the doctors, why they should disregard the testimony of Dr. Ipser. He failed with the jury. He tried to do the same thing on the motion for new trial before the judge, who heard all of the evidence presented by the plaintiff, all the evidence presented by the defendant, who observed the testimony being given, who observed the jury's reaction to it, who was in the best position to decide whether the verdict is against the manifest weight of the evidence. But the judge in that position, who's in the best position to make that decision, said no, deny the motion for new trial. So obviously you're going to have an extreme situation for the appellate court to then go ahead and intervene. The standard of review for the denial of a motion for new trial is pretty high. Its abuse of discretion has been described by all the courts, all of the appellate courts in Florida, and I don't need to rehash it. It's described on the answer brief as well. But since the appellant hasn't even moved at this level to raise the argument that there was any error in the admission of even Dr. Ipser, even though he did argue that at the motion for new trial, there's no argument on the briefs on that issue, even though he mentions, yes, I moved to strike Dr. Ipser and that motion was denied. There's absolutely no argument in the argument section of the brief about why that testimony should have been excluded. So that issue has been abandoned. And if all the plaintiff is asking, or the appellant in this case, is asking is for the court to reweigh the evidence, that is just an improper thing to ask the court to do when reviewing the denial of a motion for new trial. In fact, I haven't cited to that case because it actually came to my mind this morning driving over here. There's a very recent Florida Supreme Court case that I've seen a few weeks ago, and I haven't supplemented it with the court yet because it just came to my mind as I was driving here that is related to this case. I think where
And don't argue. If you haven't filed a supplemental?
Well, I would file it, I mean, I could obviously file it after the oral
You
argument.
can
and I
do
just
that,
thought
but we generally don't allow you to argue a case if you haven't given us the supplemental.
Well, sure.
authority.
It's black letter law, and I don't need to address that case. The bottom line is that the court's not allowed to reweigh the evidence when considering this type of issue on appeal. The jury was given an opportunity to address it. They disregarded it, so did the trial court, and then we asked the court to do the same at this level, especially because all of the evidence was admitted, and there is no argument anywhere on the briefs that it was improperly admitted. On the second issue, I don't know if the court has any question, but I would like to say that basically the trial judge was faced with a situation with Dr. Foley speaking to two jurors. The trial judge took appropriate action, questioned the jurors and Dr. Foley about what happened. He made the decision to remove the two jurors. There were 5 jurors left on the panel. He asked both counsel for both sides, do you want to proceed with 5 jurors? Both attorneys agreed. The plaintiff's counsel was agreed as well. He later moved for a mistrial, and I don't really recall seeing anywhere in the record where he was trying to use this whole incident in order to impeach Dr. Foley. But even if that is present in the record, that would be inappropriate. It's sort of like trying to present to the jury or argue to the jury during closing arguments that, well, you know, the opposing counsel was hiding evidence, you know, things of misconduct like that. And let's assume for a second that obviously that Dr. Foley was acting inappropriately and violated an order of the court just before a break in the trial took place. That's something that the trial judge should do directly with the witness. It's not something that you want to use and allow the parties to use at the trial in order to influence the jury to reach a verdict, not on the basis of evidence, but on the basis of passion and prejudice and basically anger towards a particular witness. I think that it's appropriate for the judge to allow the witness to testify and not bring all this issue before the jury. That's what the judge is there for, and the judge took appropriate action, and the plaintiff's counsel accepted to proceed with 5 jurors. I have nothing further unless you all have any questions.
Thank you very much.
May it please the court. Again, I'm going to try to boil it down to simplicity. I realize I may be butting heads, but I apologize. But I very believe that's the situation here. If the evidence presented to the jury is predicated on false information, predicated inaccurate, then that jury verdict should be in fact overturned because it's not based on proper evidence in question. Whether the court lets it in or not, or does not rule on, does not mean it's proper evidence. That's what the review of this particular court is to determine whether or not that was done is correct. My contention is by not allowing Ipswich testimony, by allowing the jury to hear this erroneous information, the fact-based testimony based upon force of impact, which was not correct because the actual vehicle, the actual door that was crushing against this individual was not presenting evidence, taints everything else that came forward. And that's the reason why this court should act on abuse of discretion and allow this case to be reversed, because this should be tried on the actual issues of this case and not based upon opinions of somebody that is predicated on falsehood and predicated on something that's not true and correct. That's the purpose of the appellate courts. I may be wrong, but that's my understanding of it. To correct the wrongs that occurred either by the jury or by the trial court. In this case, that's what I'm asking. I would ask this court to allow me to grant a new trial on the issue of damages alone, or an alternative to grant the mistrial with a dictate that the testimony of Dr. Ipswich is not to be allowed based on the photograph testimony. I thank you for your courtesy.
Okay. Thank you both very much. Thank you.